Welcome to AustLaw Simplified. In this presentation, I will show you how to answer a contract law problem question using the IRAC method. This is one of the most valuable exam skills a law student can learn. Many students know the cases, but still lose marks because they do not structure their answer properly. Today I will walk you through a simple method that helps you identify the issue, state the rule, apply the law to the facts, and reach a clear conclusion. One of the biggest reasons students lose marks in contract law is not because they do not know enough law. It is because they fail to answer the question in a structured way. Examiners want to see legal reasoning. That means you must connect the facts to the legal principles. A strong answer is not just a summary of the law. It is a careful argument showing why the law leads to a particular result on these facts. IRAC is a simple and powerful method for structuring legal answers. First, identify the issue. Ask yourself what legal question the facts raise. Second, state the rule, including the relevant principle and authority. Third, apply the rule to the facts in a detailed way. This is where most marks are earned. Finally, conclude clearly and directly. A student who follows IRAC usually writes more clearly and scores better than a student who writes in an unstructured way. The first step is to identify all legal issues raised by the facts. In contract law, common issues include offer, acceptance, consideration, intention to create legal relations, and certainty. Sometimes capacity or terms may also arise. Students often rush into writing rules before working out what the real issues are. A better approach is to pause, read the facts carefully, and list the possible issues before writing anything. That makes the rest of the answer much easier to organize. After identifying the issue, state the legal rule clearly. Avoid vague statements such as an offer is needed. Instead, explain the rule in proper legal language. For example, you might say that an offer is a clear expression of willingness to be bound on certain terms once accepted. Then support that proposition with authority. The rule section should be short, accurate, and directly relevant to the issue you are discussing. Cases are important, but they must be used properly. Do not simply drop case names into the answer. Explain why the case matters. For example, Carlill is useful when discussing unilateral offers and advertisements that may amount to offers. Hyde v. Wrench is relevant for counteroffers. Entores is important for acceptance by instantaneous communication. Balfour v. Balfour helps with intention in domestic settings, while Masters v. Cameron is often used when discussing certainty and agreements subject to contract. Application is the most important part of IRAC. This is where you explain how the legal rule operates on the facts given in the question. Students often write only one sentence here, but this is where the examiner sees your legal reasoning. You should compare the facts to the principles from the cases. Ask yourself, which facts suggest there was an offer, and which facts suggest there was not? Which facts support valid acceptance? Then explain why your interpretation is stronger. Let us take a simple example. Alex advertises a laptop online for $1,000. Ben sends a message saying he accepts the offer. Alex replies that he will think about it, and later sells the laptop to Chris. The key issue is whether a contract was formed between Alex and Ben. To answer that, we need to work through offer and acceptance carefully. We also need to consider whether the original advertisement was actually an offer or merely an invitation to treat. A strong answer would begin by identifying the issue, whether Alex made an offer capable of acceptance. The rule is that advertisements are usually invitations to treat rather than offers, although exceptional cases exist. Applying that rule, Alex's online advertisement is likely to be treated as an invitation to treat, which means Ben's message was not acceptance but rather an offer to buy. Alex's statement that he would think about it suggests no final acceptance by Alex. Therefore, the better conclusion is that no contract was formed with Ben. Before finishing any contract law problem answer, stop and check your structure. Have you identified each issue raised by the facts? Have you stated the correct rules and cited relevant authority? Most importantly, have you applied the law to the facts in a meaningful way? Finally, make sure your conclusion answers the question directly. If you follow this checklist consistently, your contract law answers will become clearer, stronger, and much more exam-ready. Thank you for watching, and I hope this helps you write higher scoring answers in contract law.